Good morning. Let's continue with our discussion of search incident to an arrest. There's one more case that I want to cover in that particular area, and that's Riley versus California. Riley versus California deal with the search of a cell phone incident to an arrest. If you remember in Robinson said that the officer can search the individual. He can search the individual that is subject to the arrest and any possessions that he may have on him. That includes containers, packages, or whatever. If it is incident to an arrest, and that is per se, automatically the officer can do it. Riley versus California involves two set of facts. It's really a combination of two cases. The first set of facts, Riley was stopped by police officers for driving with an expired registration tag. In the course of the stop, the officer learned that Riley's license had been suspended. The officer impounded Riley's car, and they impounded Riley's car and conducted an inventory search of the car. Riley was arrested for possession of concealed loaded weapons. Officers searched Riley incident to an arrest, and in his pants pocket they found Riley's phone. And finding his phone, the officer actually opened his phone, and they went through the phone, and they found information related to the Crips, which is a gang, and they saw the letter CK, which indicate Crip killers. He was at the police station about 2 hours after the arrest. A detective specializing in gangs further examined the contents of the phone. The detective testified that he went through Riley's phones looking for evidence because gang members will often video themselves with guns or take pictures of themselves with the guns. And so they actually went through his phone after the arrest, and they said that it was a search incident to an arrest. And the second set of facts, or the second circumstances, the police officer performed routine surveillance, observed the suspect making an apparent drug sale from his car. Officers subsequently arrested the suspect and took him to the police station. At the stations, officers seized two cell phones from him. One was a flip phone and the other was a smartphone. They went through the phones. And they saw that he had received calls from several calls from a particular number. They opened the phone and saw a photograph of a woman and a baby set in the phone's wallpaper. They pressed one button on the phone to access his call log, then another button to determine the phone number associated with the designation My House label. They next used an online phone directory to trace the phone number to an apartment building. They went to the apartment building, observed through the window a woman who resembled the woman that was on the wallpaper, or that was the screensaver on his phone. They secured the apartment while they obtained a search warrant. And later, executing the search warrant, they found 215 grams of crack cocaine, marijuana, drugs, and drug paraphernalia. Both suspects alleged in a motion to suppress that the evidence was found as a result of an illegal search of the phone, that it was not necessarily a search incident to arrest, that they could not search the phone incident to arrest. The court, in making a determination, looked at several things. The first thing they looked at was Robinson, because again, remember, Robinson dealt with the search of the person and any containers that the person may have on him, or anything the person may have in his possession subject to an arrest. Here, both were arrested. Cell phones were in their their possession. But the court went on to say that because the cell phone contains such intimate information, it contains information about the person's life. It contains all information many times about who the person contacts, and it contains a ton of information about the person. That in order for an officer incident to an arrest to search a cell phone, that they had to have a warrant. Let me read to you what the court said, but there were exceptions to that, and we'll get to those exceptions in a second. Robinson concluded that the two risks identified in Shamil, harm to officers and destruction of evidence, are present in all custodial arrests. There are no comparable risks when the search is of digital data. In addition, Robinson regarded any privacy interest retained by an individual after arrest is significantly diminished by the fact of the arrest itself. Cell phones, however, place vast quantities of personal information literally in the hands of individuals. A search of the information on a cell phone bears little resemblance to the type of brief physical search considered in Robinson. And so the court said that this is not necessarily consistent with Robinson, because when you're searching for Robinson, what you're searching for is basically something that may harm the officer, or that is necessarily can be used or can be, where they can find evidence that's related to the crime for which the person has been arrested. But the court says that the cell phone contains tons, as I said, tons of personal information, intimate information about the person, which would have little to do with the arrest or whether there be a danger to the officer. Court goes on. Digital data stored on the cell phone cannot itself be used as a weapon to harm and arrest an officer or to effectuate the arrestee's escape. Law enforcement officers remain free to examine the physical aspects of the phone to ensure that they will not be used as a weapon. Again, here they are saying that they cannot open the cell phone and look into the cell phone because it will not help an escape or anything that's necessary in the Robinson. But they can examine the phone itself, the exterior of the phone, for the purpose of determining whether the phone can be used or will be used as a weapon. As we go on and look at what the court finally decided and what the final determination by the court said, our holding, of course, is not that the information on a cell phone is immune from search. It is instead that a warrant is generally required before such a search, even when a cell phone is seized incident to an arrest. You can seize the cell phone incident to an arrest. Again, Robinson say any possession, anything in that person's possession at the time of the arrest, it can be seized. However, you cannot conduct an additional search of the cell phone absent a warrant. It goes on. Moreover, even though the search incident to arrest exception does not apply to cell phones, other case-specific exceptions may still justify a warrantless search of a particular cell phone. Here, the court is listing the exceptions to the rule that they have just laid down. One well-recognized exception applies when the exigencies of the situation make the needs of law enforcement so compelling that a warrantless arrest is objectively reasonable under the Fourth Amendment. Exigent circumstances is basically what the court is saying. Such exigencies could include the need to prevent the imminent destruction of evidence in individual cases, to pursue a fleeing suspect, or to assist persons who are seriously injured or threatened with imminent injury. In Chadwick, for example, the court held that the exception for searches incident to an arrest did not justify a search of a trunk at issue, but noted that if officers have reason to believe that luggage contains some immediately dangerous instrumentality, such as explosives, it would be foolhardy to transport it to the station house without opening the luggage. Thus, if there are exigent circumstances or the case's circumstances present exigent circumstances in reference to that particular phone or information that may be found in that phone, the officer can conduct a warrantless search. Again, it falls in exigent circumstances exception to the warrant requirement, which we will cover on our next video. Let's move on now to the plain view exception. Plain view exception is not a search. It's not technically not a search. Let's look at Horton versus California. The petitioner was arrested for armed robbery. Officer obtained a search warrant which authorized a search for proceeds of robbery. The officer searched but did not find proceeds. However, officer discovered weapons in plain view. The officer testified that he was interested in finding other evidence connecting petitioner to the robbery. And so when he went in and he executed the search warrant and was looking for evidence in reference to the robbery that he had the search warrant for, he was interested in finding anything that was related to the robbery, or anything that would connect the petitioner to the robbery. And thus he had an ulterior motive, but he did have a warrant. And he did find evidence while he was executing the warrant. The court had to determine, does the discovered in plain view need to be found inadvertently? And the court went on to say, that evidence that is found in plain view is not subject to the Fourth Amendment because it is not necessarily a search because it is in plain view. And thus, if it's actually in plain view, the Fourth Amendment does not apply. But there were certain requirements, there were certain elements that must be met in order to say that the evidence was found in plain view. First, for the evidence to be considered in plain view, the officer did not violate the Fourth Amendment in arriving at the place from which the evidence could be plainly viewed. That is, the initial entry must be lawful. The initial entry into the place where the officer say that he saw something, he found something in plain view, must be lawful. He must have a warrant. There must be some other exception to the warrant requirement, exigent circumstances of consent. Uh, in order for the officer to be in that place, he must be in that place, again, where he says that the thing was in plain view. He must be there legally. He must have a legal right or Fourth Amendment right to be there. Second requirement is the item is observed while the officer confining his activities to the permissible scope of that intrusion. He goes there based on legal intrusion, but the search of the item has to be observed based upon the purpose of that particular intrusion. For instance, the officer has a warrant. While he's executing the warrant, he observes something in plain view that is outside of a warrant, that is not necessarily defined in the warrant that he has the right to search for, but he was searching the place that he should have been searching in order to find that thing that the warrant gave him the right to search for. For instance, officer goes to home and he has the right to search for guns and evidence of illegal guns. So the officer can search in the closets. He can search in drawers if he's looking for evidence of illegal guns. And he can also search in areas where illegal guns may be, other areas where illegal guns may be found. And searching in those areas, if the officer also sees something that is in plain view while he's carrying out the dictates of that particular warrant, he's legally carrying out the dictates of that warrant within the scope of that warrant, and he again sees something that is obvious, that is illegal, or he believes that it's evidence of crime, then officer can seize that because it's in plain view. So the first two requirements: first, officer must be the initial intrusion must be legal. Second, he must observe the thing while he's carrying out the purpose of that initial intrusion, of that legal intrusion. And lastly, the thing must be obviously evidence of a crime. The thing must be obviously contraband or evidence of crime. It is immediately apparent, the thing has to be immediately apparent that the item is contraband or evidence of crime without necessity of further examination of a search. If the officer has to do a further examination, if he has to search and go into something beyond just seeing the thing and noticing that the thing is immediately apparent that it is evidence of crime or that it is contraband, then it is not plain view. For instance, in Hicks versus Arizona, officers received a call that there were gunshots that were being fired, and they were coming from a certain apartment. So officers goes to that apartment, and so when they go to the apartment, they're looking for what? They're looking for evidence of someone who might have been firing a gun, or evidence of something that would lead them to believe that there's some criminal activity that's related to the gunfire. Now, they go in, and when the officers get there, they notice something in the apartment. They notice some electronic equipment that was somewhat out of place for this meager apartment. They had very expensive electronic equipment there. And so the officers knew that there had been some robberies of an electronics store sometimes earlier. And so what the officers do, they take the electronic equipment and they turn the electronic equipment over, and they call the station, and they give the serial numbers on the electronic equipment, and lo and behold, the electronic equipment had been a part of the robbery. And the question became whether the electronic equipment was in plain view. The court found that it was not, because in order to determine that it was a part of a robbery, the officer had to do a further search. They were in the place legally because there was exigent circumstances. They were actually carrying out the purpose for the initial intrusion, legal intrusion, that is looking for someone who may have been related to firing a firearm, and whether everybody there was safe. However, in order to get the information in reference to the stolen items, the officer had to do an additional search. Yes, the items could be seen just in plain view. They could see the items, but the evidence that they needed in order to determine whether items were stolen, they had to do an additional search. And therefore, it was not readily available, immediately apparent that the evidence was contraband or evidence of a crime. And let's move on. One last thing that I'd like to say about plain view. Noticing an object that is in plain view does not encompass a search. The question is whether an officer can seize an object that is plain view. The plain view exception does not allow an officer to conduct a general search, only that he can seize it. One other thing too is that there's some jurisdictions have accepted an extension of plain view, which is plain smell, which is a plain smell exception. And plain smell, just as plain view, will give the person probable cause. Louisiana has accepted the plain smell exception. That is, officer goes up to a car, officer identifies the smell of marijuana. He's a narcotic officer. The smell of marijuana is distinct. He can testify to the smell. He can testify that he understands what the smell, how the distinctness of the smell, and all of those things. And thus, the officer smells marijuana. It gives him probable cause to conduct an additional search of the car for the purpose of determining whether the occupants of the car, the driver of the car, are involved in any type of illegal activity in reference to marijuana. And so, plain smell is an extension of plain view, and Louisiana has accepted the plain smell exception. Let's move on from plain view. Well, at this particular time, I'm going to stop, and our next video that I will post, because we're at 17 seconds now, will deal with the automobile search. And I will post that video immediately following this one. So we'll move on to the automobile search, and then when we come back on what's that, July the 2nd, I will go back over most of this information that we covered in these videos, and we will move on to exigent circumstances. Thank you very much. I'll post the next video very shortly.